get started. And we're going to start with Sean Bellick, and he works at CAR in the government affairs field rep, and he knows all things Prop 19. I think he's been either in or talking with Sacramento a lot lately. So we're going to go ahead and get started and welcome Sean Bellick.
Thank you so much, Jody. Hello, Santa Clara Association of Realtors. Good to see you guys again. I'm going to talk to you today about Proposition 19. Thanks again for your heavy lifting. It's been a long haul, but it finally passed in last November, and it's getting ready. It has already, part of it has already gone into effect. And so I'm going to go over with you some resources that are available to help you guys market Prop 19 to potential clients out there and learn about the benefits of utilizing this great new law. And then we're also going to talk about some of the legal resources out there to help clarify some of the ambiguities or more technical aspects of the law. So without further ado, I'm going to try to share my screen here. And actually, everything that, before I do that, copy something. Before I go to another screen, I'm going to put up in the chat here, I'm going to attempt to at least, what's going on here. Of course, everything freezes when I try to do this. Just going to try to put up in the chat here the, let me get out of that. The web page of where we're going, so you can follow along here. And then I want to make sure it goes to all panelists and attendees. Okay, so you can click on this. We're going to start with the marketing end of things on explaining really generally what this new proposition is. So I'm going to share my screen, and it's going to be the link that I just sent you, and we will share that. Okay. So you should see the website caprop19.org. And what you'll find here at the home page that we've created is a little video that explains what exactly Prop 19 is, who it benefits, why it's a good new law. And then some frequently asked questions are answered here on the two prongs of it, the portability and also the intergenerational transfer. Get the facts, some more fact sheets, and then over here where it says CAR members, that will bring you to a new website, to car.org, that I'll get into in a second. The last part here, resources, gives you the languages of Prop 1690, which Prop 19 changed, and then also some Board of Equalization information. This is getting into the legal weeds of some information that they put out regarding Proposition 19 and the advice for the county assessors. So I encourage you guys to go here. Now, when you click on CAR members, it's going to bring you to car.org, and you'll see here, do you guys see the turquoise screen? Nod yes if you see it. Hopefully you guys see the top there. It says Prop 19.
Yep.
All right, perfect. Thanks. The opportunity is now. This is the marketing end of things on how you guys can help make your clients understand the benefits of Prop 19. Right now, we're looking for stories. That's what it says, share your client story. If you have a story of how a client might benefit from this, please let us know. We'd like to get those stories out there. But you'll see all the marketing materials. There's a PowerPoint presentation that you can do, and we'll actually go into this one right here to make sure that you guys understand that. But we have a sample email letter that you can put out to your clients that talks about the portability part. We have the Prop 19 card that is designed for victims of wildfire and natural disasters. We also have the same one directed towards people that are homeowners with severe disabilities. And lastly, homeowners age 55 and over. Those are all the beneficiaries of this new proposition. So we have the marketing materials there. So when you hit download, it will bring you, I think, if this is, oh no, that's not it. Where is it here? I might have to stop share. and go to another screen. Bear with me. What we're going to do, hopefully, is go over the PowerPoint that we have out there for you guys to help understand what is going on. Let me just make sure I can find it here. Here it is. Okay. So this is the PowerPoint from that caprop19.org. That's the first page right there. We'll go to the next page. Oops, I gotta do it like that. Quick overview of what Prop 19 does. 55 and older, severely disabled, people whose homes were destroyed by a wildfire can transfer their property tax assessment value to a replacement home anywhere in the state, regardless of location and regardless of the value of the primary residence and the new or the replacement residence. They have 2 years to do it, and they can do it up to 3 times. All right, that is the portability part. That goes into effect April 1st, 2021. Now, currently under current law, Prop 1690, homeowners who are 55 and older, they can only do it once. It has to be within the same county, and they can go to another county, but there's only like 10 of them that accept you. And the replacement property has to be equal or lesser value than what you sold your first home for. Okay. The new rules, which I was on the previous slide, go into effect again April 1st. Now, Proposition 19, the new parts of it, again, just emphasizing you can go anywhere in the state, regardless of value, and do it up to 3 times. So this kind of gets into some ambiguous questions that were raised after this law was passed. And mainly it goes after, well, if you have 2 years to complete the transaction and it goes into effect April 1st, 2021, can you simply go back 2 years and say, hey, if I've done one of those, either bought a replacement home or sold my home, if you've done one of those, can you do the other one by April 1st, 2021? And we believe the answer is yes. We admit that it is a bit ambiguous. And since the question has been raised, we cannot say legally that that is what you can do. So we have introduced some cleanup language legislation, which is common after a new law goes into a place, to kind of fix these gray areas. And we're hoping to clear that up very soon, hopefully before April 1st. It's already made it through its first committee and is now pending a final vote in the Assembly. So the Assembly floor, that is. So we're hoping to get official clarification on that issue. Again, we believe that if you go back 2 years from April 1st, 2021, if you've done one of those things, then you can complete it on April 1st, 2021. The bottom line is you're not attorneys and you don't have a fiduciary duty to give legal advice. Instead, consult an attorney and get an opinion that covers yourself and your client. And also you can reach out to a tax professional and maybe get some advice as well. So the next slide that we'll go into, again, just talks about under current law, and then it goes into what's equal or lesser value. We actually do the math for you here. For the sake of time, I'm going to skip over that. But that shows you basically take the difference of what your home sold for and what the replacement home cost, and whatever that difference is gets added to your original property tax base. This talks about the intergenerational transfer rules. That's the second prong of kind of what Prop 19 changed. And this basically goes into the ability for parents to transfer over their properties, their homes, to their children, and have their children basically pay the same property tax that their parents did, or grandparents if the parents are deceased. So the old rule was the principal residence, regardless of its value, could be transferred to the children, and then additional property, whether it's a second home, a business, up to $1 million could be transferred as well and maintain that same property base. The reason why we went after this is that this was probably going to be eliminated by the voters and or the legislature. This was on the chopping block. It was raised issue. And so under our proposition, we actually maintained it. It was kind of a compromise. It says if you want to keep the family home in your family, you can, but you got to make it a primary residence. And then that anything over $1 million increased value basically will be added on to the original tax base. So it was a compromise, and that actually went into effect February 16, 2021. And I believe the next slide shows you exactly how that works with inheriting a property. And so let's see the next slide. Okay, I think that's it. So before I go, I just want to go over one more thing with you guys here. And where is it? Let's see. The legal questions. I promised I would get you some hard legal advice here that you guys could take to the bank, so to speak. This is located, and I'll put it in the chat, at our legal website. Paste that here. At car.org. We have a whole folder dedicated to Prop 19. We have a quick guide. We have the whole breakdown on the portability, the intergenerational transfers. We take you to the BOE FAQ on that. It shows you more equations right here. I would go there. And then the last place I would go for specific questions is our legal hotline, which is there 6 days a week. And that number is 213-739-8282. I'll put that up there. I'll put my email because I actually have another meeting I have to run to. So I don't know if we have time for questions. I'll be happy to help take some if there is time. And I'm just typing up my email up there in the chat. I'll stop my share here. And we'll turn it back over to Jody and see if they want to do questions now, or they can email me. I've got about 10 minutes before, or more plus, to jump onto another meeting. So it's up to you.
Okay, there is somebody, I see somebody has their hand raised, but if you could put your question in the Q&A box, we're not really able to unmute anybody to ask questions. So if you've got questions for Sean, anything about Prop 19, please go ahead and put those into the Q&A at the bottom of your screen. And then I can ask him. Tim, I know you're on this call. Do you have anything for, any questions for Sean, maybe that you've heard while I wait for maybe that person to put their question into the chat box?
Hi, Jody. For those of you who don't know me, my name is Tim Bobie, and I'm the Director of Government Affairs here at SCORE. I've been working really closely with Sean and CAR on this entire Prop 98 process. But I think that pretty much covered all of the information and pretty much mirrors everything that I've been promoting in our marketing meetings. I think we're just kind of waiting right now in that phase for some of that cleanup legislation to possibly pass, but the website and the other resources that Sean threw in the chat are a fantastic one-stop shop for any Prop 19 questions you all have. I continue to promote those in all of my government affairs newsletters, which I have one going out tomorrow. So if you lose the links for those ever, it's an easy, quick search on the CAR website, or just keep an eye out in my newsletters.
Tim, I see a question, or
Yep.
Go ahead, Jody.
I was just going to say, I see 3 of them that have come in right as we were talking. Thank you, Tim. So the first one is, if a child buys the property from a parent, so I think the key word there is buys, would they still get Prop 19 tax benefits, or does it need to be done where no money changes hands and it's a gift?
They're going to make their kids pay for the house? What? No, it's any transfer, including a sale. So it just has to happen within a year, and you claim it on February 15th. You have to claim it by February 15th of every year.
Okay. Can Prop 19 be used for a second home that was lost in a fire?
Unless that home is the primary residence, no, it can't be, unfortunately.
Okay. And when do you anticipate the cleanup legislative will be either addressed or passed?
So it's on its third reading right now on the assembly. So we hope it can get out, hope maybe this week. And then it goes to the Senate. It's going to be expedited. So, I mean, we're hoping to do it, maybe in a week or so. But the goal is definitely before the April 1st date. So that there's, again, we're confident you can do it, but we just want to make sure everyone's legally tight on that.
And there's a question of how far back does Prop 19 go? Property was trusted to the son from the father in 2019, then to an LLC in 2020.
So regarding the intergenerational transfers, anything that happened prior to February 15th or February 16th, so anything February 15th and backwards, it will not impact. It's not going to go retroactive.
Okay. It says they're getting charged back taxes from 2019. I don't know.
Call a lawyer.
Yeah, I was gonna say, because trusts can get a little bit tricky. I think the best advice there is first, maybe see what the CAR legal hotline has to say. I will throw that number in the chat because that's a free resource for all of our members, but you're probably gonna need a more specific trust or tax specialist attorney.
Yeah, the LLC, this isn't legal advice, but the LLC may be of more help to you than the trust, because typically when it's a trust, the way it worked with the other intergenerational, I forget what proposition it was, they look through the trust who the beneficiary owners are. So the trust may not necessarily be the answer.
And we do have a brunch and learn tomorrow. If anybody wants to join, I can also put that. We have an attorney that is going to be speaking on Prop 19, and maybe you can ask that question to her and maybe she can give you information. So again, I'll put that in the chat as well if you want to come in for that tomorrow. And Darlene shaking her head. I think she knows about trusts and agrees with us that talk to an attorney. Cool. I don't see any other questions that have come in. So Sean, I know you've got to jump to another meeting. We thank you very much for spending some time with us today.
My pleasure, anytime. And again, my email is seanb@car.org. I put it up there in the chat, so you might want to scroll up and you could copy that as well. So thank you so much. Sorry I have to leave early. Bye-bye.
No problem. Thanks, Sean. All
And
right.
as a quick note, sorry, Jody, I will
No.
throw my email in the chat as well as your local government affairs representative. I am always, a resource to connect you to CAR, NAR, any advocacy questions any of our members have.
Perfect. Thank you, Tim. And now I'm going to introduce Anne Michelle Francis. And she is an eviction specialist helping all of the landlords out. She's going to give a quick overview of what's going on in the eviction world. And then we can do a couple questions after that. And take it away, Anne Michelle. Thank you.
Thank you, Jody. Thanks for having me here. I am going to share my screen real quick and share a presentation because I do feel like it's a little bit easier to see it than it is to just say it. So I am going to talk about the COVID Tenant Relief Act of 2020. So this is also known as CITRA, is how most of us in the profession refer to it. It really dictated what is happening in eviction law. It was passed, it became effective as of September 1st, 2020. And so this has changed everything about evictions. There is an eviction moratorium right now. I will talk about what that exactly means. Yes, we can still do evictions, but there are very few and far between. So let's get started. So I want to start out by saying I do have a Facebook group called Handling Problem Tenants Like a Boss. I go live every Thursday at 11 a.m. and talk about industry topics. Generally, I talk about the most common themes from the entire week. I answer questions, but I am live and I have an entire database of videos starting with the eviction moratorium. And I went live every single week during it. And I continue to as well, talking about the rent relief program. So every topic, I generally am live for 20 to 30 minutes. And this particular presentation today is pretty short. And so if there's any information you feel like you're not getting from this, I highly recommend you join that group. And I have the URL there on what as well. And it's also on the bottom of each page of this presentation. So I do want to start with a professional note. Because this is addressed towards real estate agents, and I know a lot of real estate agents dabble in property management. I want to emphasize this is not the time to dabble in property management anymore, and this is not the time to self-manage properties anymore. This is the time to hire a professional property manager to manage properties for you. They are trained, they are highly skilled. You should ask for their certifications. It is not just one certification, then you are set it and forget it anymore. This is ongoing education. It's attending these types of real estate meetings, and it's you should be learning something every single week, at the very least every single month. And if you're not, then you should start working up a referral network of other property managers who can. I do have a database of property managers who do not sell real estate, who just want to manage the property, because I know that is a concern for real estate agents. So there are those people out there that will manage it and they'll hand it back to you for the sale. So don't rule out the working with other people. So I want to throw that out there first, because this is complicated and it is very detailed, and you can get fined, and especially in this environment. So the COVID Citra in a nutshell. Number one, it requires notice from the state of California. I can give you a copy of what this notice is, or you can Google it online. You would look for the notice from the state of California for tenants, and every tenant needed to receive that by February 28th, 2021, if they missed at least 1 month of rents payment between the time period of March 1st, 2020 and present. So now it's March, and maybe you haven't served the notice yet, that's fine. Still get it out there. It's going to alert the tenants of their rights. I've heard recently people saying, I don't want to give this to my tenant because they're paying me on a separate payment schedule, and I don't want them to know that they don't have to pay me until June, so I don't want to give that to them. We don't know what the repercussions will be if you don't issue them this notice, but this is your fair warning that this is required to be issued to any tenant who is behind on at least 1 month of rent. And that is one of the things that Citra required. Citra also only gave 3 reasons to issue a 30 or 60-day notice. So if you've been issuing 30 and 60-day notices or notices of non-renewal, you most likely are not allowed to be doing that. There are very specific situations and documents that need to be served in advance. I will talk about what those are. It also took away 3-day notices. There are no more 3-day notices to pay rent or quit during the pandemic. So no 3-day notices should be served between March 1st, 2020 and June 30th, 2021. That's assuming the eviction moratorium is not extended. We believe it may be extended, but during this time period, there are no 3-day notices for non-payment of rent. Instead, it changed the 3-day notice to a 15-day notice. And this 15-day notice has several documents that are attached to it and separate requirements. Our 15-day notice is about 7 to 8 pages to make sure that we have all of the documents to be in compliance with California. So I would if you are thinking about serving a 15-day notice, you should hire a professional. If you're thinking you might want to evict based on the 15-day notice, you should hire a professional. This is not the environment to do this on your own. And a certified property manager will also know that as well. Once you're talking about eviction in a non-compliant tenant, you want to make sure that you're doing it all correctly. Next time, the 2 separate time periods of rent are due is what Citra created. This is the biggest part of Citra that also can be the most complicated. So I want to slow down here and talk about what these 2 major time periods are. The first is the protected time period, and that's from March 1st, 2020 to August 31st, 2020. So these were basically the times we were on lockdown in California. The second time period is a transition time period from September 1st, 2020. Sorry, I have 2021 on there, but it should be 2020 to June 30th, 2021. Again, this is it. Originally, that date was supposed to end in January. They extended it until June, and there's been rumor for months that they'll extend it until December. But as of right now, that next time period ends at the end of June. So what are these 2 time periods, and what does that mean? The protected time period is the first one. And what that means is that the state said that if tenants owe any rent during this time period, they don't have to pay it, and they are not at risk of eviction as long as they return a declaration of COVID impact to you. So all they have to do is sign a document. They do not have to prove to you that anything on the document is correct. Yes, they are signing it under penalty of perjury. However, there are 6 different reasons on there stating what their impact is. They don't have to tell you what it is. They don't have to prove it to you. And if they sign that, then they are protected under that protected time period. They don't have to pay you back for that time period of rent. You can't evict them for not paying you any rent during that time. And you can take them to small claims court, and this becomes a consumer debt when small claims opens again for COVID cases. And the plan is for August 2021, again, assuming the eviction moratorium is not extended past June. If it's extended again, then they will delay the small claims court opening as well. The two are related. The second time period is the transition time period. This is September 1, 2020 to June 30th, 2021. So the state again has declared that the tenants owe the rent, but they only need to pay a small portion of the rent that's due by June 30th, my dates I did not write correctly on here, by June 30th, 2021, as long as they returned their declaration of COVID impact to you. Again, as long as they sign that one declaration, I call this the golden ticket in a lot of my presentations, as long as they sign their name, date it, sign under penalty of perjury and say that one of these 6 reasons is a reason that they can't pay, then they qualify for these protections also, which means they don't have to pay until June 30th, 2021. So even if they're behind on rent, they don't owe you anything until that one magic day. And on that magic day, they only need to pay you 25% of the rent that's been due through that entire time period. So from September through June, they have 25% of the rent due by June 30th. Now keep in mind that does not say 25% of each month. So if the tenant paid in full from September until March and then doesn't pay you April, May, June, they've still paid the 25% minimum and they're clear. So you can't evict based on non-payment of the other percentage there. So this is only for rent that is due between September 1 and June 30th. It's due by June 30th. And again, if the eviction moratorium is extended, this payment amount will be extended also. So far, it has been extended 1 time and it was extended 5 additional months. What is an eviction moratorium? You hear about this, but do people actually know what it is? Well, you think that it means there are no evictions. Well, it depends. It means different things at different times depending on the law. The first time period is March 1st to October 5th. I know I've got more time periods here, and these are different time periods, and they don't necessarily coincide with the notices I was talking about. But this new time period, March 1st, 2020 to October 5th, 2020, there were no evictions. The courts were closed. It was impossible to file an eviction. They weren't taking them at all. There was one exception to the rule, and that was if the tenant was a threat to the public's health and safety. If they were a threat, then you could process an eviction. I will tell you during that time period in our office, I have been specializing in evictions for 16 years. Our attorney has been specializing for 40 years. We had 2 eviction cases that were a threat to the public's health and safety. One of them, the tenant ended up moving out. The other one, we started in June and we had the eviction in November. That was the rush for the public's health and safety. Time period. So there were evictions, but only for that one particular situation, which still was not fast. Time period 2 is October 5th to January 31st. So during this time period, so this was after the first version of Citra passed, also known as AB 3088. This meant evictions could be filed, but only for certain scenarios. One being non-payment of rent after being served a 15-day notice, and also breach of contract for tenants behaving badly. For example, having parties, being loud and rowdy, threatening and intimidating other neighbors, holdover tenants. There were scenarios where we could still kick people out if they weren't following the lease. And then there were the 15-day notice ones. Now, keep in mind with that 15-day notice, all they had to do was return that declaration and then they're covered. So you can't evict if they return that declaration, but some people didn't return the declaration. And so those evictions could be started. Time period 3 is where we are now. So there are more reasons that we can start evictions now, or more reasons we can issue notices to start evictions. However, evictions are still very minimal. February 1st until June 30th now means evictions can be filed, but there are limited scenarios, and relocation assistant is required as well. So the same 2 that I just showed in the last slide. Actually, I don't know how to go back to my last slide. Okay. So the same 2 here, non-payment of rent after a 15-day notice and breach of contract, those still exist in the time period we're in now. So those still apply in addition to these additional items, which are reasons you could serve a 30 or 60-day notice. Owner move into a property, and it's very specific who owner move in means. It means the owner, the spouse, domestic partner, their children, grandchildren, parents, or grandparents. It does not mean my cousin, my third cousin, my relative down the street, or someone that I think is my brother. Okay, it's very specific who owner move in is. And generally we say that it means the owner needs to move in for a couple of years. It's not, I'm just moving in and then moving out for like 2 months later just to get the property back. There are two notations on that and a notation on the next one. I'll talk about that in a minute. The other exception is that you could serve a 30 or 60-day notice for is if the property is in contract and the buyer intends to occupy it as their primary residence. This is another reason you would be able to issue a 30 or 60-day notice. Now look at the notation, the asterisk at the bottom. You can only use those two reasons for a 30 or 60-day notice if you had already issued a notice to maintain your exemption from statewide just cause prior to July 1st, 2020. If you have no idea what I'm talking about, if you have no idea what that notice is, then I guarantee you did not serve it. I have never seen somebody serve it if they have no idea what I'm talking about. It's usually a real estate professional, a property manager who has a whole stack of them that they serve to all of their tenants. It's very rarely the individual landlord or the property manager or someone who's dabbling in property management who has issued this notice. So you need to be very careful. If you did issue this notice, then you can use the owner move-in option or the option for the property being in contract and the buyer intending to occupy it as a primary residence. Okay, those are the two options, but only if that notice was served. If not, those two are off the table for you. Then the last is withdrawal from the rental market. This, I hear real estate agents try to use this the most often because they want to withdraw from the rental market so they can sell the house. If you choose to do that, make sure you are disclosing it to the buyer because it's a very real scenario that the buyer buys it and then finds out that they can't rent it out. And this is a problem. Who's keeping track of it? It just depends. If there are fines that are associated with it, then you can believe that California is probably going to find a way to figure it out. So I wouldn't mess around with it at this point. I would just be very cautious of it. You can use withdrawal from the rental market, even if you did not issue the notice to maintain exemption. You should plan to keep it withdrawn for 2 to 3 years after you withdraw it. And this is the option that you can use, but you should definitely disclose it to any buyers who may be possibly purchasing it as an investment property. So in response to that, a rent relief program was created at the federal level, and $1.4 billion was issued to the state of California. This particular program will reimburse owners for 80% of the rent, as long as you're willing to waive the other 20%. The caveat is that the tenant needs to prove that they were impacted. So far the tenant hasn't had to prove anything. They could sign a declaration and not pay their rent, and eventually you can sue them in small claims court, and eventually they may owe 25% of the rent. This is different. Now they're saying we have a federal program that's run through the state, and now we are going to give you 80% of the rent back. So who doesn't want to be part of that? Of course, everyone wants that. And starting March 15th, which was just this Monday, you could apply online at housingiskey.com. It's pretty straightforward. It's a relatively simple form asking information and proof of ownership. But the part that they're not sharing is that not every single person will qualify. So the funds will be distributed in 3 rounds. The first round is those who make less than 50% of the median income based on household size. Round 2 is those who are disproportionately impacted communities. I'm not exactly sure which communities those are. That hasn't been released, but that is round 2. And then round 3 is all others. So it's basically in these 3 phases is how those funds will be distributed. It is not first come, first serve, although they are recommending that you do that right away. So recommended actions from the state are: number 1, apply as soon as possible at housingiskey.com. And when you complete the application, look at the pre-application checklist. I also have this in my private group if that's something where you want to see what that checklist is laid out for you. So you want to have all of your documents and ready to upload. And most importantly, you want to make sure you have accurate information for your tenant, because your tenant is just as necessary to this process as you are. So the tenant needs to comply and needs to talk in order for you to get the funding. You can apply for any back rent, but only for these time periods. So I'm going to say, don't get greedy. Don't ask for more than this. This is the only time period that they will grant you that relief from. So it's April 1st, 2020 to March 31st, 2021. If the resident applied first and you've been notified, then cooperate. Just give them the documents that they need to prove that you own the property. Take the 80% if you're granted it. And tenants aren't prioritized, or tenants are prioritized. Number 1, on housing instability. So if they are at risk of eviction or homelessness, they are prioritized. It is not first come, first serve for them. So the rent relief program, tenants will qualify as long as they can prove all 3 of these things: the reduction of income, They have to demonstrate housing instability, and that actually will boost them to the top of the list if they are at risk. And they need to make below 80% of the area median income. So if your tenant does not fit all three of those scenarios, then you're not going to qualify for this rent relief program. There are three scenarios that can happen. Number one is the landlord applies, then the tenant cooperates with the landlord applying, then the 80% funding will be issued if they're one of the qualified people, and the funds will be issued directly to the landlord. So the landlord is the one who will get the money. Scenario two is the tenant applies, and for some reason the landlord doesn't cooperate. So landlord's completely unresponsive. Maybe the landlord doesn't, maybe they had bad contact information for the landlord. So that's something else to think about. Make sure that the tenant has your contact information as well. Tenant applies, landlord doesn't cooperate, tenant still gets 25% funding, and it's issued directly to the tenant. And the tenant does need to sign information saying that they're going to pay it to the landlord. But it's 25% funding, and notice that that amount matches the amount that will be due by June 30th. So they will be clear, and you would have to go to small claims court for any consumer debt. One additional item to note is if you go to small claims court for that additional 75%, part of Citra is that they have said that it is at the judge's discretion to determine if you are entitled to that 75%, because if there was state funding that you did not comply with, then the judge can reduce the total amount that you're owed if you were not in compliance to try and get the state funding. Scenario three is the landlord applies and the tenant doesn't cooperate. So maybe the tenant doesn't cooperate or doesn't qualify, then the application's terminated. So for the tenant, if they apply and the landlord doesn't cooperate, they get all their money so that they're clear. But if the landlord applies, tenant doesn't cooperate, then the application ends right there. The major caveats of the rent relief program is that the tenant does need to qualify for the funding by meeting those certain income thresholds. If the tenant never had to prove that they were impacted and financially unable to pay in the first place, they may not even qualify. So the owner's still stuck and still doesn't have funding, even though there are the funds there. And we also have no idea how long it will actually take to get the funding. Some word on the street has talked about it being funded by June 30th, which is the date that tenants are protected through. So it's possible that even though we're applying now, we won't have results for several months. Our office policy is that we would like you to serve a notice. We would like you to apply for the rent relief program and use one of our notices as your exhibit for proof of what the tenant owes. And then we can start the eviction, and hopefully the housing instability and risk for eviction will put you up a little bit higher on that list and make it a priority so that you can get funding. And let me go back here. So one more time, I was going to say my Facebook group is where you want to go and get more information. Again, that link's at the bottom. The laws are confusing. Make sure you get legal advice. Hire a certified property manager who does not sell real estate so that they are not your competition to manage your properties, and work out an agreement to get those properties back to sell them. There are property managers who do that, and they're fantastic property managers. Keep in mind that fines are increased by 10 times for landlords who are doing things wrong, and defense attorneys are free for tenants, and they're paid for by your tax dollars. So be careful. And that is where I'm going to sum things up. This is, again, my group. You can look it up on Facebook by Handling Problem Tenants Like a Boss. There are 3 qualifying questions that you need to answer to get into the group, and you will join my distribution list where I'll email you and let you know what I'm talking about each week, or you can type in the URL right there. I'm going to stop sharing that and answer if you guys want to give me any questions, or I can address them at the end.
Thank you. And I did, just for everybody, I looked up those, so I copied the link and put it in the chat box. So if you just want to click directly on that link, and I also put your email address in there, and Michelle. So thank you. So until questions come in,
I was going to say, Jody, I've gotten a couple of questions from
Perfect.
members already that I've been hearing. Can I lead with those?
Please do.
While we're waiting for some to roll in.
Yep.
And I will promote in Michelle's Facebook group. I am a member of it. I attend the live update every week. It is fantastic. The first question I've been getting is, how is the state constituting or figuring out the 80% AMI? Is it based off a 2019 tax return? If they had a job pre-COVID and lost it, are they basing it off the AMI of the job they don't have anymore? Kind of, how are they working out that formula?
Those are good questions. Those are not related specifically to an eviction, but I do know that there are calculators on the site. So as you're going in to apply, there are specific calculators that can help you figure that out. So it's not a guessing game. You should know at the time of application.
Okay, awesome. And secondly, oh, I am blanking right now. I don't remember what the second question is that I've been getting. But that's good information. As I said, we have a SCORE website up now dedicated to the rental assistance program statewide. So those of you that are looking to apply either as a tenant or a housing provider, check it out. It is a housing provider checklist. It has the tenant checklist, everything in there that you need. And I remember what the second question is. If the tenant is applying just for the 25%, you said they had to sign something that says they're going to pay that money to the landlord. If they receive that 25% and they don't pay the money to the landlord, can the landlord prove that they never received the income and then start to move forward with an eviction?
So the landlord, it means that the landlord has completely not responded and has not complied in order for the tenant to get 25% and the landlord to not get 80%. So it's very important for the landlord to participate. Another note that I did not mention before is that both can apply. The landlord can apply and the tenant can apply, and it does not create a double application. They merge together, they join together, and each one can submit their own separate documents, and the other party will not see what those documents are. And so they can both do it together. So the landlord can apply, tenant can apply, and then everyone's on the same page. It's really just detrimental if the landlord's not responding, then you're dealing with that 25%. And I'm assuming that's going to be very minimal. I don't know what landlord is not going to comply, except maybe those who are evicting because of breach of contract, because there are some pretty naughty tenants out there that are going through eviction.
There's two questions that have come in. One of them is the landlord application fee. No, the landlord application refers to fees other than rent. What kind of fees can be included in the applications?
So if you go back and there's a button that says I'm a landlord, I think it's a yellow button when you go to apply, and right below it, it says sample application. And if you click that button, you can see all 9 pages that you're essentially signing and that you're agreeing to. And in that, I believe it's sections 4, 5, and 6. I posted this today in my Facebook group. I believe 4, 5, and 6 tell you what those incidental fees are. So we also thought that you could not ask for rent, but those particular sections refer to late fees and utilities, and they refer to possibly being reimbursed up to 15 months in utilities. So look through that section and see how that applies to you.
Okay. We'll do 2 more questions and then we'll go to Darlene for her PPP SBA and then come back to all the questions at the end. So one of them is the tenant owes $36,000 in back rent, refuses to leave. The house has been in escrow for 60 days. The tenant wants a jury trial, which isn't happening till at least June. And they're afraid the buyers are going to back out.
Sounds like you have legal counsel already if you have a jury trial coming up. So I would definitely call your attorney.
Yep. And then I think this is one we get a lot. The owner wants to sell their single family rental after the lease expires in June. So they just want to sell it, not move into it. The tenant has lived there more than a year. Is it okay if the landlord gives a 60-day notice of non-renewal?
No. So no notices of non-renewal right now. I'm hesitant. So it's the end of the lease is the end of June, and we have the eviction moratorium expiring at the end of June. So the 2 are coinciding and it may extend, right? So I'm not encouraging any notices of non-renewal. That would be one scenario that may be okay. You could do owner move-in, you could do withdrawal from rental market. Those all depend on whether or not you have issued that notice to maintain exemption. So there really aren't any straightforward answers for anything. I need to look at all the documents to see what you have and what kind of tenants they are, and if they're more helpful and agreeable, or if they're going to put up a fight. Do they owe rent? Also, there's just a lot of other scenarios we need to talk about. But I'm not recommending any notice of non-renewal because it's just not covered. And we're all assuming this is going to be extended. So at the end of it, you may have nothing. So why not go with something stronger like owner move-in or in contract with buyer intending to occupy as primary residence. But again, you had to have served that notice to maintain exemption. So it's a little tricky.
And correct me if I'm wrong, Ann Michelle, but I think the American Rescue Plan, the new federal stimulus package that just got passed, actually extended the federal eviction moratorium into the fall. So I wouldn't count on that June 30th, drop deadline of eviction moratoriums just ending.
Right. The best thing that I've been able to do this whole time is let people know most things will get extended, but I go out teaching what we know, which are these hard dates. The hard thing about that is that people get a date set in their mind, like January 31st and February 1st. People are saying, wait, well, what's going on? I want to start my eviction. No, it was extended to June. So the best we can do is give you what we know right now. And we think it's all going to be extended significantly.
Okay, we did get some more questions, but I want to get to Darlene to talk about the PPP SBA updates, and then we'll come back to the eviction and landlord questions. So I do have them in there, everyone, but we're going to get to Darlene with updates again on the PPP and SBA loans, and she's an attorney with Hoag Fenton, which is based here in Silicon Valley and also in the Tri-Valley area. So Darlene, welcome and thank you.
Sure. Thank you, Jody. And thank you, everyone. Good afternoon. And let me share my screen. Can you see my screen now?
Yes, we can. Thank you.
Okay, so first, I'm an attorney from Hoag Fenton, and I'm based in the Pleasanton, Tri-Valley area. I'm a corporate attorney, and I advise all sides of clients, entrepreneurs, founders, and also well-established companies through that full life cycle of the company from formation to exit. And so I got into this whole PPP issue and the matter since last March when the American CARES Act first signed to law by President Trump. So now we have two new stimulus package authorized and signed to law since last December. So my presentation will talk about the highlights of these two stimulus plan and how they updated the PPP program. So this presentation is information purpose only, and it's not constitute legal advice. And if you have any specific question, and then you can contact me afterwards. I will put my numbers and email in the chat. And so let's start. So the overview, I will first start with the Consolidated Appropriations Act 2021, which signed to law on December 27, 2020. We often call this as the second stimulus plan as compared to the CARES Act, which is the first stimulus plan. So this act includes a roughly $284.5 billion COVID-19 relief package known as the Economic Aid to Hard-Hit Small Business, Nonprofits, and Venues Act. In short, it's Economic Aid Act. So the Economic Aid Act makes available to fund and reopen the PPP program for first and second draw loans on terms that are generally favorable to micro business. So you may ask what considered as micro business, generally speaking, is referred to business with less than 5 employees and with asset and sales revenue below $250,000 annual. So the application period for PPP Round 2 loans will end on March 31st, 2020. Congress is talking about to extend that deadline to May 31st, but nothing has been finalized. So if you want to apply, still use the March 31st as the deadline. So there's an exclusive PPP loan application period from February 24 to March 9 for borrowers with 20 or fewer employees. So, that deadline is already passed, but it doesn't mean that you cannot apply. You should still, apply before March 31st, 2021.
Hey, Darlene, I don't know
Yes.
if you advanced your slides or not, but we still see the first one. So I just want to make sure.
Oh, okay. Sorry about that.
It's okay.
Can you see now?
We just see your main, like the non-presentation mode, if you will, of the PowerPoint.
Can you see now?
Nope.
Okay, let me do this again.
There we go. Perfect.
Okay,
Thank you.
sure. Okay, let's move on. So if you haven't applied the first PPP loan, you are still eligible. You can still apply it right now. And then there's certain borrowers are now eligible for a second draw PPP loan up to 2 million. This is for entity with less than 300 employees and have used or will soon use the entire amount of their first PPP loans, experience a decline in gross receipt of at least 25% during any quarter of 2020 as compared to the same quarter of 2019. So the maximum loan amount for food services and lodging businesses increased to 3.5 times average monthly payroll. And but for any other business, the loan amount still remains at 2.5 times the average monthly payroll. So some updates, as you know, for the PPP, in order for the loan to be forgiven, you have to spend 60% the loan proceed on eligible payroll cost, and the 40% on non-payroll cost. So under the Economic Aid Act, they added the following categories into the mix of forgivable payroll costs. So basically it's all the insurance, the group life insurance, disability insurance, the vision, and the dental. Before, those costs cannot be added to the payroll costs, but now they can. And then they also expand the non-payroll costs that are eligible for forgiveness. So this is pretty helpful as well. That include operating expenses, payment for business software and cloud computing services, costs related to property damage, vandalism, or looting resulting from public disturbances that occurred in 2020, worker protection expenses, and the facility modifications necessary to comply with COVID-19 safety guidelines. So if you buy PPE, and you arrange your office to keep the 6 feet distance, all those expenses can add to the non-payroll cost subject to forgiveness. Of course, and the cost of supplies essential to entity operations. So if your loan amount is below 150,000, you can use the one-page loan forgiveness application, which is called a Form 35 OAS. It requires you to describe the number of employees you were able to keep on payroll as a result of loan, estimate total payroll costs, the total amount of your PPP loan, and the request forgiveness amount. So, and also if, I didn't have the slide for the information I'm going to talk about next. So if your loan is below 50,000 under the Economic Aid Act, then you're exempt to comply with the headcount requirement and the compensation level requirement. So if you're short of maintaining the headcount and short of maintaining the compensation level, if your loan is under 50,000, you're exempt from those requirements. So it's really friendly to the micro business owners. So EIDL updates. So under the economic injury disaster loan, any EIDL advances you receive as a borrower is no longer deducted from borrower's PPP loan forgiveness amount. Instead, anything you receive between January 1st, 2020 to April 3rd, 2020, you can refinance into the PPP loan. So you can add it to your new PPP, application. Borrower will not be allowed to refinance an EIDL loan into a second draw PPP loan. So this refinance is only available for the first draw PPP loan application. So this is really helpful. I don't know if you have any clients there, running a bar or a comedy club. So this program is really for these borrowers. It's called the Shelter Venue Grants. So the Economic Aid Act provides $15 billion for grants to live performance, museum, and movie theater operators that have been forced to close due to the pandemic. And the eligible recipients must show that they have suffered a 25% reduction in revenue in the first, second, or third quarter of 2020 as compared to the same quarter in 2019. So under the Economic Aid Act, if you receive this grant, you're not eligible to apply for the PPP loan. But last week, President Biden signed the American Rescue Act, that new stimulus plan law, amend this clause. So now, you, a venue owner, you can not only apply this grant, but also as well as the PPP. So under the latest, the American Rescue Act, a venue owner can apply both PPP and this shuttle venue grant. So that's good news. So the terms of this grant program is that, it doesn't need to be repaid since it's a grant, and the grant payment will be equal to 45% of the venue's 2019 gross revenue, and it must be used, the grant, for payroll costs, payments on any covered rent obligation, mortgage payments, loan payments, covered worker protection expenditures, payments made to independent contractors, but kept under 100K in annual compensation, other ordinary and necessary business expenses, and you cannot use the funds received from the grant on the purchase of real estate loan payment originally after February 15, 2020, investment funds or for political contribution. So I don't know if any of you have employees, but if you do have employees, you can claim for employee retention credit now under the Economic Aid Act. Before, if you're a PPP recipient, you cannot get this credit, but now you can, but you can only claim the credit on employee wage, not paid PPP funds. So the requirements is that employee must either have the operation of the business fully or partially suspended due to orders from government authority limiting commerce, travel, or group meetings due to COVID-19, or suffer 20% reduction in gross receipt when comparing any quarter in 2020 to the same quarter in 2019. So this is a brand new program under the Economic Aid Act. It's called a Target EIDL program. So this provides an additional $20 billion for emergency EIDL advances of up to 10,000 through December 31st, 2021. You may be eligible to receive funds up to 10,000 if you are located in low-income community, previously received an EIDL advance for less than 10,000, or previously applied but received no funds due to lack of available program funding. So to be eligible for Target EIDL advance, you must have suffered greater than a 30% economic loss in 2020 as compared to 2019, and have no more than 300 employees. So I think that's pretty, relatively easy to meet this requirement. But you can use the mapping tools to locate low-income community, because that's one of the requirements. Your business had to be in one of these low-income community, then you can apply this Target EIDL program. So you don't need to apply by yourself, and the SBA will reach out to you if you're qualified. So unemployment benefits, I got a lot of questions from people say, can I get unemployment benefits at the same time get PPP? The general answer is no or yes. You can apply both, but you cannot use claim for the same period of time. So under the Economic Aid Act, they expanded employment benefits, which known in the Pandemic Unemployment Assistance, or PUA, provided an employment recipient with an extra $300 per week. So the PUA coverage has been extended through March 14, 2021. So if you're a state, so this program is run by the state. If your unemployment benefit is $500, then under this program, you will automatically, have $300 increase. And the maximum number of weeks an individual can receive PUA has been extended from 39 weeks to 50. So if an individual is received PUA before March 14, 2021, but has not received the maximum weeks of PUA, your coverage can extend to April 5th, 2021. So they want to make sure you have the 50 weeks, coverage as of April 5th, 2021. So the PUA made unemployment benefits available to sole proprietors, independent contractors, and self-employed. They will continue to be eligible for employment benefits in this new bill. So here's the latest, we call the stimulus package 3, which is the American Rescue Plan Act 2021, was signed March 11th, 2020. March 11th, which is last week. So it adds billions of new funding to expand the PPP to eligible additional nonprofits and online news publishers. And they also created $28.6 billion restaurant revitalization fund to allow eligible restaurant may receive, to receive tax-free federal grants from the RRF equal to the amount of its pandemic-related venue loss for the period from February 15, 2020 to December 31st, 2020, if certain conditions are met. So, but the maximum grant size is $5 million for restaurants and $10 million for restaurant groups if they have multiple locations. As I said, they amend the Economic Aid Act and allow PPP recipient to apply for an SPV grant, which is the shuttle venue grant. Expand the PPP loan forgiveness to include payments for premiums on behalf of individuals who qualify for COBRA health insurance continuation coverage. So only applies to no forgiveness application received after March 10, 2021. So that's also good news. Those expenditure you can add it to that 60% the payroll costs for forgiveness. Extension of ERTC all the way through the end of calendar 2021 under the Economic Aid Act. It only covers through first 2 quarters of the 2021. So that's called the employee retention tax credit. So that's, okay. So the last slide, I just want to touch base on the state program. In California, we do have a California Disaster Relief Loan Guarantee Program. It provides for disaster relief guarantee program to help mitigate barrier to capital for those small businesses that do not qualify for federal disaster funds, including business in low-income and immigrant communities. And the term is up to 7 years, and that's the state provides up to 95% guarantee loan, and the loan interest is negotiated between lender and borrower. So this is sound less attractive than the PPP because there's no forgiveness feature, and the PPP loan rate is 1%, and here you have to negotiate with your borrower, so which is uncertain. And the eligibility is small business located in California with 1 to 750 employees that have been negatively impacted or experienced disrupted by COVID-19 eligible nonprofits. So if business that over 500 that not qualified to apply PPP, then this is an alternative because it has a large threshold to up to 750. So that's end of my presentation, and I'm open for any questions.
Thank you, Darlene. That was honestly, one of the most comprehensive, but understandable presentations of all of this. There's a lot out there, and I know it's been confusing, especially now that there's a second round. So if anybody has any questions, please put those into the chat box or the Q&A box, and we'll get to those. And then in the meantime, Darlene, I'm going to put your email, excuse me, into the chat box just in case anybody has any questions. And sometimes it takes a little bit for people to get them in. So I think what I'm going to do, if that's okay, Darlene, is jump back to the some of those tenant landlord questions, and then as the different questions come in, we'll just kind of jump back and forth. So Anne Michelle, starting back with you. You mentioned the state form. It says the landlord required to give to all tenants if the renters are paying and have paid rent during the periods. So it sounds like, yeah, you've got to give them the forms.
Yes, you have to give them a form if they missed at least 1 month payment, and it will notify them of everything I just talked about in this presentation, the protected period, the transition period. I believe it's a 2-page document. If you need that, so it's in my group, or if you need it, you can Google AOA, it's Apartment Owners Association, and SB 91, and they have free forms there. You can download one of their forms. They put free forms out. I don't recommend you use them to actually serve notices and legal notices. You should be talking to someone in the profession before you do that.
Okay. Owner wishes to sell the single family resident oh wait, we did that one. Sorry. On behalf of college students, and this is actually one that I think really happened last year and has gone on. They obviously, college students signed leases at apartments that they were going to be in, and they didn't occupy the apartments because COVID was, they couldn't. Do they have any protection from any responsible rent?
I have not heard of any separate protection for them. Usually college students are co-signed by their parents. And so their parents are the ones who are doing the negotiating with the landlord. Honestly, everything comes down to how easy the landlord and tenant are to work with. If the tenant is saying, I don't want to pay you anything, and I just want to get out of this because college isn't in session, and the landlord's saying, well, I need something. I mean, everything is a negotiation. Everyone's out right now. So what can you do to make amends and compromise? Even if you go to court, the judge wants you to sit outside and negotiate before you actually take something to trial. Work it out. And if you don't work it out, that doesn't look favorably if you're not trying. So both sides need to try and work things out. And some sides are going to be more stubborn than others. So I'm not aware of anything particularly addressing college students in that scenario, because it would really be their parents that are the ones in the leases, usually, because college students shouldn't be able to really apply for a unit on their own.
It's shocking what they allow college students to do. And then they turn around, they're like, wait, I got a credit card, I have to pay that back, wait. Yeah. I remember those college days. Darlene, a question for you. Many real estate agents are sole proprietors with an hourly assistant. This person has obtained a small PPP loan number 1. Of the new programs, which would be most appropriate to apply for?
I would say still the PPP. As I said, for loan amount under 50,000, there's a lot of exemptions that you don't need to comply with the your loan still will be forgiven if you do not meet the headcount requirement and the compensation level requirement, the threshold, and also the process is much easier. And you can get the PPP and also the EDIL if you're in a low income community. That's the target EIDL program is also something you can look into it. The application process it's pretty straightforward for the EIDL. SBA has its portal, you can apply it. Yeah.
Okay. I have a question that I thought of. Sometimes real estate agents are sole proprietor because they've got their own real estate business, but some of them have another job on the side to help supplement income. If they have a supplemental income maybe a full-time job and they're doing real estate as a second job or as a second career,
Mhm.
can they still apply for a PPP loan?
Okay, so if you belongs to a real estate company that you have an employer, and that employer can apply the PPP, right? But if you have a separate business and most of your income is from that business, then you can, as a sole proprietor or as an independent contractor, you can apply as well. So you can check with your accountant the way they calculate the loan amount is to look your Schedule C in your 2019 Schedule C, look your net profit. And there's a formula which is published on March 3rd, the interim guidance by the Department of Treasury is that you divide by 12. But if your net profit is above 100,000, you have to cap at 100,000. Then you divide 12 and time 2.5. And then if you have any EIDL refinance, you add that amount and then minus the COVID-19 EIDL, which, I don't know if you have it, it's the $10,000 that everybody tried to get it in the last March. If you have any of that, you minus that. So that's how you calculate as a sole proprietor, for that portion of the PPP loan amount.
Okay.
Yeah.
And I assume the business has to be profitable. If the business has losses, it probably don't get.
Yeah. That's because you use your 2019, filing as the benchmark, right, to do the calculation. Yeah.
Okay. And Michelle, is it reasonable, or is there any risk if you ask a tenant for proof of income if they plan to apply for the program before applying as a landlord? It looks like there's a breach of contract and they need to be certain if they qualify. And they're not just stalling an eviction.
That's kind of two separate things. So there's breach of contract, or is it non-payment of rent and they need the rent relief program?
I feel like there's probably both.
Okay, so you're gonna have to pick. You can't move forward on if you're moving forward on breach of contract, you're saying I don't care about the rent because this violation is more important. If you're moving forward on non-payment of rent, then I don't want to say you're waiving the breach, but essentially you're saying that it's not that important because you'd rather have rent. Because in the event that they qualify for the rent relief program, then they will get that funding and they'll keep them there. So I think maybe that's what they're debating, is which one do I move forward on? So you can only ask for proof of income if they're a high income tenant. And there's a separate spreadsheet category. You can Google it and see what a high income tenant is. I believe off the top of my head, it's 2 adults who make more than $198,000 a year. So it's actually a pretty high cap, and you can't ask for that proof unless you have documentation proving that they already are a high income tenant. You can't guess. So say they're an engineer at Google, but you never got pay stubs and you don't have any tax information. You can't say, well, I know you're an engineer, so you need to prove it. It's the other way around. How good were your records when they moved in? What's your application say? Then you can say, okay, you're a high income tenant, but otherwise it doesn't, you can't ask. They are entitled to that privacy.
Okay, that makes sense. Do you foresee, we just saw somebody that typed in they had $36,000 in back rent. Small claims court in California is now $10,000. So if you have, a tenant and you can't get that 75 or 80% because they're not cooperating, maybe they just decided to not pay rent because why? And now you're trying to get the money and they're not cooperating. Do you think the courts will allow for larger small claims cases, or can you file multiple?
They've made it unlimited. So they've made it unlimited, but that particular branch of small claims is not opening until after the moratorium expires. So right now we're saying that's June 30th. So small claims will open in August in order to bring the judges up to speed with what those requirements will be. But it will be, there is no cap and there's no limit to the number of small claims cases you bring forward. So
Wow.
you can demand $36,000 in small claims. Now, again, one of the caveats I had said is that if you did not, the landlord did not comply with the program and did not provide the information they needed, and they go before the judge can reduce that judgment to whatever they want. That is part of SB 91. So you should do everything within your power to try and work with your tenant and get the funding.
Okay. There was
Question
one,
that I don't think we answered in the chat, Jody, that I think pertains to Darlene and Michelle is when will the COVID benefits expire or no longer eligible to apply? My knowledge is, the funds and the resources are there until they run out, but you both can expand on it further if you would like.
I know for the state funding, the rent relief program, it's until the funds are exhausted.
Yeah, that's pretty much for the PPP as well. Yeah. It's
And
basically first come, first serve. Mhm.
in the most recent American Rescue Plan passed by President Biden, there's another 21 billion of rental assistance allocated federally. So the state is about to get a second influx of cash into that fund.
I guess they're trying to help people.
Mhm.
But
A
not the
question I just thought of, and Michelle, is you said one of the reasons that you can evict somebody is if you want to put it on the market for somebody that would like to own or occupy it. How would a duplex fit into that? So you may be renting out both units of a duplex. You want to put it on the market for a prospective buyer who wants to live in one unit and rent out the other, but you have two tenants in there right now as an investment. How do you pick which one to keep? Do they both get evicted?
Good question. I haven't been asked that question before. Once you start talking about AB 1482 and just cause, and is it owner occupied and withdrawing from the rental unit or from the rental market, another thing is that it has to be in contract already, and the buyer has to intend to occupy as their primary residence. So you can't put it on the market. So it really has to be a real estate agent who knows people, like has to have another network, I think, so that they can already be in contract on a property and know that the buyer wants to occupy it. Then I would assume, and this is just a guess, I would assume that they can choose one unit that they can occupy, and that's the one that they could withdraw. That's the way that it was before when we were still dealing with statewide just cause on its own. But remember, we only had 2.5 months to process statewide just cause before COVID kicked in. So really nothing's been processed as AB 1482 at all, because we never brought any of those cases where we were issued 30 and 60-day notices to court. And really court is what's deciding, the judge is what's deciding what we can do on those cases. So we never brought those to trial. So that's why it's still a gray area. We still are not there.
and I just want to let everybody know, I just put 2 classes in the chat box. One of them is tomorrow, just more information about Prop 19. We have an attorney that's going to come in and speak. And then next Tuesday, there've been a couple questions about commercial. That eviction moratorium as of today is up March 31st. So we have an attorney coming next Tuesday for our Legal Tuesday, who's going to talk about what that means, because it's very different than residential, as Michelle and I have talked about a little bit, with payback of rent and how people can potentially get out of leases. So both of those are free. You can register at both of those links that I just put into the chat box.
And we may get another update on Tuesday. I know that the Santa Clara County Board of Supervisors is hearing an agenda item next Tuesday to potentially extend the commercial eviction moratorium past that March 31st. So we
Josh
may know
speaks
on
it too,
Tuesday
so-
during that webinar that it could be extended.
Mhm. Is that on the docket for the evening?
Santa Clara County Board of Supervisors meets at 9:30 in the morning.
Okay.
I think it's towards the top of the agenda, so we might have an answer by the webinar next week. No guarantee.
Okay. Does anybody have any more questions, thoughts, comments for Anne Michelle, Darlene, or myself and Tim? I see a hand raised, and I see your hand raised, Tammy. If you could put your question in the chat box real quick. Unfortunately, I'm not able to call in anybody, but Darlene, do you think there'll be another round of PPP, or I know you said till it's exhausted. Is it exhausted out of this round, or is it just they may just keep going?
We don't know. We really don't know. And if I think, this round, the fund got exhausted very quickly, then there might be, another round, in the next stimulus plan. But if the trend has slowed down, and then, they may think that's enough. Yeah.
Okay.
So we'll see. Yeah. Mm-hmm.
I have heard from Congress and the president's office that they are not interested in a next stimulus package anytime soon. They're going to kind of see how vaccines go.
Yeah. Mm-hmm.
As case rates continue to drop, and whether one would be needed, but it seems unlikely.
Yeah.
Okay. We did get another question for you, Anne Michelle. If there's one person on the lease, but 2 people living there against the contract, yep. How does the income limit apply? Do we have to look at the 1-person household per the agreement? My assumption is yes.
Depends on several factors. First of all, did they waive the fact that there is a subtenant? How long has that tenant been there, and how long have they known that that tenant's been there? Has that tenant been there for a year, or has that tenant been there for 2 weeks? If they've been there a year and they've never done anything about it, never served a warning notice, then that's your tenant. Now, if you don't know that person's name, then don't find out their name. You don't have to go out of your way to figure that out. However, if that tenant has ever paid you rent, that is now your tenant. So there are a few qualifying factors that depend. A lot of people want to call them squatters and things like that. And really, they may actually be your tenant, depending on what your behavior has been with them.
And I've also heard that once you accept rent, you've accepted the rent. That you can't go back and say, well, they only paid me $800. Well, you accepted that. So I've heard that. So I just put, there's a couple more questions that got in here. Anne Michelle, I just put your information in the chat box, and Darlene, I put your information in the chat box. This was recorded. I'll get the PowerPoints and get them out to everybody. But Darlene, there's just another question in here about PPP. Did you say that for PPP number 2, under 50,000 of the loan amount obtained under PPP 1 would be subtracted?
No, that's not what I'm saying.
In addition to, not minus.
I think does he mean the EIDL?
I think if you got the first you got the first PPP loan and you want to get a second one, you don't have to deduct what you already got.
Oh, no, it's totally separate. Yeah, so you're only eligible to apply the second draw if you're going to use up all your first one. Yeah.
Got it. Okay, that makes sense. All right, well.